So I know normally I'm coming to you and I'm talking to you about topics like immigration law or criminal law or constitutional law. Well, this week we're going to do a little change of pace. And that's because there was a decision that came out in August, last month, August of 2021, that I have a personal interest in because it involves the ownership of the copyright of the Phillie Phanatic. And I happen to be a lifelong Phillies fan. Now, a little caveat up front, I'm not a copyright attorney. So I can explain to you a lot about this case, and I think I can do a better job than the media. I was reading a lot of the coverage in the media. It made me want to go back and read the entire decision, which I did, and I understand it better from my own reading. I think I can explain it better to you than the media, but of course, a copyright attorney can certainly give you a much greater detailed analysis than I can. And if there's a copyright attorney out there who happens to be watching this, who wants to correct things that I'm saying or make what I'm saying more accurate, please, by all means, let me know in the comments below. I'm happy to be corrected by somebody who knows something more about this than I do. But it is an interesting case. The Phillie Phanatic. He's that green, lovable mascot. We Philly fans, we think he's the greatest mascot in all of sports. He's funny. He's been around since 1978. And believe it or not, when I was a child, I went to the first game where the Phanatic was introduced in April of 1978. 6-year-old me went with my parents. We would go to ball games often. I mean, I practically grew up at Veterans Stadium with my parents taking me to Phillies games. So I saw the Phanatic as he was introduced, and I went to a number of his birthday games, a number of games that every year in April they celebrate the Phanatic's birthday, and they have a very special, it's a great event to go to if you're ever in Philadelphia in April, to go see the Phanatic's birthday, because they have a really nice ceremony. At any rate, I want to talk about this litigation over the copyright regarding the Phillie Phanatic. And let's do a little background, because this is a very interesting, fascinating case to me, because it shows something very strange, at least the way I see it, about the operation of copyright law in the United States. So back in 1978, the Phillie Phanatic was introduced. Back then, Bill Giles, who eventually became the president of the Phillies baseball operations, back then he was in charge of promotions. And he kind of grew tired of the Phillies' old mascots, Phil and Phyllis. They were the constitutional, the colonial-looking characters. Children, they were supposed to look like, dressed in colonial garb that represented the Phillies, Phil and Phyllis. And he wanted to update that, so he wanted to come up with the new mascot. Initially, he contacted Jim Henson. Jim Henson got him in contact with another creator who Henson used to work with in order to create his characters, Harrison Erickson. The company was known as Harrison Erickson. And Giles contracted with Harrison Erickson to create the Phillie Phanatic. He gave him some general ideas. I want this big, fat, green creature that roots for the Phillies to be really silly but lovable. And based on that, they came up with the design, gave the Phillies a costume. So the Phillies assigned one of their employees, Dave Raymond, to become the Phillie Phanatic. And Dave Raymond injected a lot of his own personality into the character and basically established the character of the Phillie Phanatic, the lovable character that I grew up with and that is still used today. Even though Raymond is retired, there have been a number of people who have been inside the costume. They have been trained to personalize, to bring alive the Phillie Phanatic in the same personality that Dave Raymond created it with. So they created it in 1978. The Phillies contracted with Harrison Erickson to create the Phanatic. They created the Phanatic, and by operation of law, understanding some copyright, when you contract an independent contractor to create something for you, the contractor, the independent contractor, owns the copyright of that creation. That's how the basic common law of copyright works. Now, if it were an employee, if it was somebody who was in the Phillies employment who created the Phillie Phanatic, then the Phillies would have owned the copyright. And for whatever reason, the Phillies did not alter that by contract. Maybe they wanted to see if the Phanatic would be successful, and if he wasn't successful, well, if they didn't own the contract, or if they didn't own the copyright, they wouldn't be making much of a risk. So the creators still owned the copyright back in 1978. Between 1978 and 1984, Phanatic became wildly popular. Wildly popular. He's now a cash cow for the Phillies, and is still wildly popular after 40-some years. And but between 78 and 84, he became wildly popular. The Phillies capitalized on that. They had Phanatic toys. They had Phanatic on the Phanatic on their pennants. They had books, children's books about the Phillie Phanatic. They marketed. They really merchandised the Phillie Phanatic, and there was some dispute about how the Phillies were using him, and Harrison Erickson did file some litigation back then, and it was settled. And how it was settled is that the Phillies wound up purchasing the copyright of the Phillie Phanatic from Harrison Erickson way back in 1984. Well, there's this weird quirk in copyright law, which is after the creator has assigned away a copyright, sold it, gave it away, just assigned a copyright to somebody else, that they are allowed to reclaim the copyright. They're allowed to terminate the assignment, to terminate the contract and reclaim the copyright. So, and they can do it 35 years after they have done the initial assignment. I think there's a window, the way I read the statute, I think it's like a 5-year window from 35 years to 40 years after they've assigned it. At any rate, they can reclaim it. And the only reason I can think that this exists in copyright law is to allow a creator to step back and see and say, hey, wait a minute, this thing that I created, this piece of art that I created, I got taken advantage of. I sold it at a really low price. It became really popular and really valuable. And now I want to be able to take it back and realize some economic value from what I've done. That's what I think is the purpose behind this. So Harrison Erickson, the creators, decided that's what they wanted to do. So 2018 came along, and they gave notice to the Phillies that they wanted to terminate the copyright assignment, which would mean that the Phillies would no longer own the copyright to the Phillie Phanatic. And this created huge uproar. In fact, there was a lot of publicity about, oh, the Phanatic might become a free agent, they might shop him around to other teams. It's interesting because the magistrate in this case said, yeah, there's no real evidence that they would have done that. It was just some language that they used in negotiations for puffery. More likely, Harrison Erickson was trying to negotiate a higher price for the copyright, that once they terminated it, they wanted to sell it back to the Phillies, but they wanted to sell it back to the Phillies at the highest price that they, the creators, could realize, and so they threw in a little threat, a little puffery. We might sell this and I'll become a free agent. But that was the thing that hit the news way back 2018, 2019. Oh my goodness, somebody else could own the Phanatic. So the Phillies, they panicked a little bit, but they also, what they did is they decided that they were going to create or alter the Phanatic. So they changed the way the Phanatic looked a little bit. They changed around his eyes. They were, like his, I guess you would call them his eyelashes or his eyelids were kind of oval shape, and now they were star shaped. They made the Phanatic a little bit skinnier, but they gave him a bigger butt. They changed his feathers on his tail. They gave him these weird scales on his arm, and they changed his snout. His snout was like a conical snout, and they changed it to more of a straight snout, and basically said, okay, we had a hand in creating this character. We don't think you have the right to take him away. We're just going to use this new Phanatic as we have created him, and we're going to ignore your termination of our assignment in the copyright. And at the same time, the Phillies filed a lawsuit. They filed a lawsuit in the U.S. District for the Southern District of New York in order to make the claim that either the creators could not terminate the copyright, or that the Phillies had some rights in the Phanatic copyright, and that the Phillies had the right to use them. They wanted that kind of a judgment, and that case went to the district court. Now, we've got a decision that came out in August. It's a decision on summary judgment. Now, let me do a little explanation of procedure here, because that's one of the things that I find was missing in the media coverage, is an understanding of the procedure. When a case gets filed in a U.S. district court, it gets assigned to a U.S. district judge. But U.S. district judges, well, they're overworked. They have a huge caseload. So what they tend to do is they have magistrates, they're judicial officers. They're not quite judges, but they are judicial officers. And they're empowered to do things to help out the trial judge. So the trial judge could concentrate on the trial judge's other cases, his bigger cases, where his attention is needed, and the magistrate can deal with some other issues. And in this case, a magistrate judge was assigned the role of giving recommendations on this motion for summary judgment. Now, what is a motion for summary judgment? Basically, a motion for summary judgment is where the parties either agree or where it is shown that there's no genuine issue of triable fact, meaning that most of the facts are known. Most of the facts are known, and you don't need to put on witnesses to explain how the Phanatic got there. They don't need to explain the past litigation, who owns the copyright, and this makes a lot of sense. A lot of this stuff is established. The Phillies in '84 bought the copyright to the Phillie Phanatic, and now it's 35 years later. They did some changes. All that is a matter of public record to the Phanatic's costume, and the owners want to take back, or the creators, I should say, want to take back the copyright. So that's all a matter of, that there's not much there to contest. That's why we're on summary judgment. And this is a judgment that would be issued based entirely on the application of the law. So let's get into the law. Let's get into basically a summary of what the judge said and what this means both for the Phillies and for the creators going forward. First, the Phillies made a claim that they had some rights in the copyright of the Phanatic, that the Phanatic was more than just a statue or a costume, that it was a character, and that the Phillies, because there was input from Bill Giles 40 years ago, because of the way that Dave Raymond characterized the Phanatic, that they had a role in creating the character, and therefore they should be recognized as having some ownership rights over the copyright of the character. So the magistrate said you can have a copyright in a character. However, in this case, the judge did not think that what the Phillies contributed to the Phillie Phanatic really was significant enough to allow the Phillies to have ownership of parts, or at least a partial ownership of a copyright over the character. And think about it. Take James Bond. Ian Fleming wrote a number of James Bond novels, and he developed the James Bond character over that series of novels, so that Ian Fleming had a copyright in the character of James Bond that he could then sell that copyright to the character to a movie company, a movie studio like Sony. Sony, I believe, now owns, or at least has a license to use, the James Bond character in their films. So the magistrate judge did not think that the Phillies contributed enough in order to have a copyright in the character of the Phillie Phanatic. So let's then move on to the next issue, which involves derivative works. Now let's take a step back, talk to you about derivative works, what that means. When you create something, you create a piece of art or some other copyrightable object, thing. You have the right not only to that thing, but also to all derivative works. Like George Lucas, he created Star Wars. His company, Lucasfilms, owns, or at least they still own it, but Lucasfilm is owned by Disney. So Lucasfilms owns Star Wars and all of the stories. Well, a derivative, right, would be, for example, somebody who wrote a novel using all of the Star Wars characters in the Star Wars universe and just creating, a completely different novel, another story set in the same time period. That would be a derivative work. If you think about the Muppets, there was a show back in the 90s, I think, that was called Muppet Babies, where they took the Muppets and they changed them a little bit and they made them younger and they made them babies. Muppet Babies. That was a derivative work from the Muppets. Well, a copyright holder has the right to derivative works, and in particular, a derivative work that they create. And there's this interesting hiccup in copyright law where if you have one of these creators who terminates the contract after 35 years, well, the copyright holder for those 35 years still has, they created a derivative work during those 35 years, and now the copyright has been terminated, their ownership in the copyright has been terminated, they still have the ownership of the derivative works that they created. So the Phillies were making a claim that the current Phanatic was a derivative work of the original Phanatic. That yes, they had the Phanatic from 1984. That version of the Phanatic is what is the subject of the copyright termination, and that the changes that they made to the Phanatic between 2019 and 2020, when they added the stars to the eyes and the weird things to the arms and changed his body and changed his snout, that was a derivative work that now the Phillies had proper ownership of, regardless of what happened to the 1984 version. And the court agreed. Yeah, you made sufficient changes that it was a derivative work, but at the same time, we can still recognize this as the Phillie Phanatic. It's a derivative work. The Phillies created that derivative work while they still had the copyright. They own the rights to that derivative work, and now that you have, you the creator, have terminated the assignment of the copyright, okay, you get what you had in 1984, you don't get the derivative works that the Phillies created. And that's what the magistrate judge ruled on that issue. And then the final issue, was it proper to terminate? Did the creators properly terminate? And the magistrate basically said, yeah, there's a proper termination. So the creators own the copyright to the Phillie Phanatic as it existed in 1984. Well, as I said, this is an interesting quirk because think about the outcome of this. The creators, Harris and Erickson, went into this thinking that they could terminate the assignment of the copyright and basically force the Phillies to pay them more money, to force more money out of the Phillies. And instead, they terminated the copyright, or they terminated the assignment. They have the copyright, but because the Phillies created this derivative work, that is the current Phillie Phanatic, that they are using, and the Phillies still have the right to it, well, what do they get out of this? They don't get to bilk the Phillies out of more money for their original copyright, because the Phillies can continue to use the Phanatic as he currently exists. The Phanatic that's changed, that was a derivative right. So, in a sense, instead of being in a better position by terminating the assignment of the copyright and being able to negotiate a better deal for themselves, they're in a worse position because now they own something, but the Phillies are using something else that they have the right to, and instead of being able to earn a lot of money from the Phillies, they've just spent a lot of money in litigation fees. That's gone, that they're out. and that they're not going to be able to recover from the Phillies. So they're in a worse position, even though they exercised this right that Congress created that was supposed to benefit the creator. Not just, it's a weird quirk, I think, of copyright law, that, yeah, there's this ability of the creator to terminate the assignment or a contract that gave a copyright away, but because the people who held the copyright for 35 years could create a derivative work and still use that derivative work, it's useless in this case. It's for the original copyright owners. The Phillies can still use their Phillie Phanatic. Now, is there still some... First of all, the point, this can still be appealed. This can still go to the U.S. Court of Appeals for the Second Circuit. So the litigation is not over. But practically speaking, what does that mean, right? Because, I'll tell you, as a Phillies fan and as somebody who has loved the Phanatic for most of my life, I'm not too keen on all of the changes on the Phanatic. I mean, there are a lot of things I can live with. I just came from a Phillies game last week, and, a lot of the changes, they're not even really noticeable. In terms of how he got a little skinnier. Yeah, the fact that he's got a bigger butt, that's a little noticeable. It's kind of funny. The fact that he has these scales on his arms, like, no big deal. The stars around the eyes I actually like. I don't like the new socks. They changed the socks. But the thing that I really don't like, but I can kind of live with it, the thing I really don't like was the snout. The snout is straight instead of being conical. I really miss the conical snout. And I think a lot of Phillies fans would rather have the older Phanatic instead of what we have now, or maybe some kind of amalgamation of the older Phanatic with what we have now. Maybe there's still some economic benefit for the Phillies if they were to try to get the copyright to the 1984 Phanatic in order to change the Phanatic back. But honestly, I'm not sure that that is really worth much. I mean, let's talk about strategy here. I mean, yeah, they can continue to litigate. That is, Harrison Erickson can continue to litigate. But, to what end? They're probably not going to win, at least I don't think that they're going to win at the Second Circuit. Again, if you're a copyright lawyer and you have a different opinion, by all means, let me know. I don't think that they're going to win, but there's some strategy. Yeah, they can keep the litigation going, hoping that what this does is it forces the Phillies to the bargaining table and makes the Phillies purchase, give them money for the 84 copyright. And maybe it's not as valuable as they thought 2-3 years ago, but maybe they can still get something out of it. Now, from a strategy point of view, if I'm the Phillies, I just won this. This is a big victory. They can continue to use the current version of the Phillie Phanatic. What's the value to them of the 1984 Phanatic? For one thing, what can Harrison Erickson do with it other than try to get money from the Phillies? I mean, can they give it to another team and sell it? Well, yeah, it's possible. But what they'd be selling would be, the big green creature. They wouldn't be selling the uniform that the Phanatic wears, because those are all trademarks of the Phillies, right? So they couldn't sell him the uniform. They couldn't use him, like I was thinking, well, maybe they could make a series of children's books using the Phanatic from 1984. Yeah, they could, but he wouldn't be wearing the Phillies uniform. They would have to put him in some other kind of costume. Sure, they could probably do maybe a series of children's books, and I don't know, the Phanatic's wearing a Hawaiian shirt or something, or some other type of costume, and make it funny, and maybe they could earn money that way. I don't see them selling it to another team because I just don't see another sports team coming forward and angering the Phillies by taking the Phanatic. I just don't see it. I don't think sports teams are willing to operate in that kind of an environment. I think to some degree, with respect to, say, free agents on the fields, when it comes to trademarks, they have a common interest in protecting each other's trademarks. So I don't think that they would want to anger the Phillies by, buying rights to the Phanatic without, the Phillies uniform. So there's really not much that Harrison Erickson can do except continue the litigation to try to get more money out of the Phillies. And then the Phillies strategy, I would think, is if they are interested in getting the 84 copyright, the copyright to the Phanatic as he existed in 84, and I think there would be some interest, but there's some value to that. I mean, there's a limit to the value, right? I mean, it wouldn't be worth millions and millions of dollars, that's for sure. What would it be worth? If I were the Phillies, I would be asking my attorneys, okay, what do you have as an estimate of what I would spend in litigation fees and expenses in order to defend this in court? The attorney would give them an estimate, and that would be my upper limit. And yeah, I might go and try to negotiate with Harrison Erickson. I'm not going for the upper limit. I would start really low. Okay, give you a couple thousand, give you $5,000 for the copyright. You know, and just test to see how high or how low they could get it, with that ceiling being the litigation cost. Because, you know, if they're getting that high, they might as well fight it. So with the ceiling being the litigation cost, to me, what would they take? Maybe the Phillies could get the 84 or the copyright to the Phanatic as he existed in 84. But anyway, it's an interesting case. How that's going to turn out, I don't know. It certainly clarifies a lot of things, because the Phillies can continue to use the current Phillie Phanatic. And as I said, I thought this was an interesting case, again, because to some degree it's because I am a lifelong Phillies fan, but also because it's an interesting quirk of copyright law, that it's an area of law that I don't get to practice much. And, you know, it's just very interesting that even though this is something that was designed to help a creator, that the way this played out, because of how derivative works operates under law, the creator just basically, did not get, is worse off than if they just let the Phillies have their copyright. So anyway, that's this week. We'll get back to immigration topics next week. Give us a thumbs up if you like this little detour into a different area of law. Subscribe to the channel so we can talk about more legal issues in the future. Tell your friends about us. As always, thank you so much for watching. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.